How recently have you spoken to Apple in the context of mediation, and what have those talks in the mediation context centered around?
Well, I have not spoken to anyone personally regarding mediation. There are court-ordered mediations that happen regularly during these litigations, not the ITC, but the other two cases we have, both in California and Delaware. But those are just kind of pro forma meetings. No one from Apple has reached out, and I'm not here pleading for that, but I've offered an olive branch. And if there's a way we could work together, that's fine. If not, I'd rather compete in the marketplace with my technology, not in Apple's products.
Joe, just to be clear, in the context of Masimo, the company, because there are other executives, I'm sure you have strong internal legal counsel and outside counsel, there have no conversations taken place at all between your company representatives and Apple company representatives?
Well, no executives are talking to Apple. None of the Apple executives are talking to us. There are court-ordered mediations that I can't get into that have been held before, and there will be additional meetings probably in the future. But those are not meetings that I consider steps towards settling litigation. As you know, Masimo, being the inventor of measured through motion and low precision pulse oximetry, successfully sued and won two other big cases that took each 6 to 7 years. One with Nellcor, which is part of Medtronic, one with Philips. Once we got an injunction on Nellcor, the CEO of, at the time, Tyco Healthcare called me, apologized, and said, would I meet to settle? And we met, and within 30 days we settled. Those kinds of calls have not happened.
And Joe, we will get to the technology discussion in a moment, but you are the CEO of Masimo. Last year, you had around $2 billion of sales. That's about 5% of the segment Apple reports that includes wearables. So it has been hypothesized that a licensing agreement or royalties is one possible outcome. That must be something that you are pushing for hard, because it would have a material or needle-moving impact on your sales.
It takes two to tango. Whether we want it or not, it's got to be both parties that want it. There are positive reasons for both of us to have it. Probably the biggest positive is the consumers getting a reliable, accurate pulse oximeter, no matter whose watch they're wearing. But yeah, while I would be happy to have a settlement that's a win-win, I did not file this litigation because of that. I did it because, first of all, principally, it's wrong what Apple does, taking smaller companies' technologies. And in our case, they stole our people, they stole our patents, and they stole our property. So I had no choice to go after them. I'm the CEO of Masimo, and I have to defend Masimo's intellectual property. And in our case, as you know, we make products. You just mentioned we have $2 billion in revenue. The wearable market is a $50 billion revenue. We make the most accurate and reliable pulse oximeter. Even when Apple was making their watch, they thought the most important feature of the watch is pulse oximetry. I have that. I have the medically FDA-cleared product, and it really works. So I intend to get in the marketplace and hopefully gain our rightful share of the market.
We showed Apple's statement on the screen a moment ago, but in summary, Apple fundamentally believes that the patents are invalid in the first place in the context of this ITC battle and the associated court battles, and that Apple fundamentally believes they do not infringe them, that their products, as they are today, do not reflect what is reflected in the patents. So you make two competing arguments here. How are you going to prove the opposite is true of that statement that I've just summarized from Apple?
We're no longer alleging Apple infringed our patent. Apple has been proven to infringe our patents. And not only the ITC, which the judges, our patent lawyers, reviewed, had a hearing, looked at the evidence, and found our patents to be valid and infringed, but even PTAB, that generally kills 80 to 90% of patents that are brought in front of them in an inter-party review exam, found these patents to be valid. In fact, it's funny because when the judge ruled in our favor, Apple told the commission, which is the commission's full appeals group, that, hey, don't pay attention to what your judge did. The real expert is PTAB, and they're going to invalidate Masimo's patents. I think 2 weeks later, they did not. And then they said, no, we only meant you should look at that if they found Masimo's patents to be invalid. No, our patents are valid. We are the inventors of this technology. My co-inventor went to Apple and took this technology to them. The only two companies that had this convex shape correcting for light piping so that you can get accurate pulse oximetry were Masimo and Apple. I wonder why.
Joe, I'm focusing on the ITC decision and ban from October because that is the latest, right? That the action Apple has to take today, selling the Series 9 and Ultra 2 with the functionality disabled, directly relates to that process. So that's why I'm focusing there. And in the original ITC decision from October, you submitted 5 patents in the context of that case, right? The ITC, as you say, found that 2 Apple had infringed, and within those 2, you were allowed to proceed with 5 claims. But in all, you made more than 100 claims, and the ITC allowed you to move forward with 5. To play devil's advocate, how is this not to be interpreted as just throwing everything you can at Apple to see what sticks?
Well, first of all, in the entire history of Masimo, and we've had 2 major litigation, none of our patents have ever been invalidated. In 2012, under the American Invents Act, PTAB was created to look at people filing processes to kill people's patents. But unfortunately, they created what is known as is not clear and convincing evidence to kill a patent, but preponderance of evidence. And that is why 80 to 90% of people's patents are getting killed. And Apple happens to be the #1 customer of PTAB. So focusing on the ITC case, focusing on this particular litigation, none of our claims were invalidated. ITC itself found our patents to be valid. Some of them they didn't think Apple infringed. Some of them they thought they did. And some of them they thought we didn't have domestic industry on. So no, we have not thrown our patents against the wall to see what sticks. We've been in business for 35 years. I'm one of the co-inventors of this technology that's revolutionized pulse oximetry, that saved babies' eyesight, that has helped people not die of opioid overdose in post-surgical wards. Over 200 million people a year are monitored with our technology. And when Apple wanted to make their pulse oximeter, what did? They went and hired my team, as many of them as they could, to develop it for them. So I think this narrative is false. And given that Apple was found to infringe, not just by the ALJ, by the commission, several agencies for President Biden reviewed this to see if they should intervene. They didn't. And the Court of Appeals just enjoined them during the appeal process. To have someone say to me, oh, Apple thinks your patents are invalid. Well, you know what? They have their own, what do they call it? They call it this fake reality. I read it in the biography of Steve Jobs. They can live in that reality if they want. But really, should the rest of us?
Joe Kiani, Masimo CEO, we're grateful for your time. And I think that what it's clear you and Apple agree on is that pulse oximetry can confer a real benefit from a healthcare perspective to the consumer. One of the arguments that the consumer might make, and was flagged to me on social media when I said you were coming on the show, is that there are people that want to buy the Series 9 and Ultra 2, right? Apple has a great installed base of devices around the world. And there are consumers, therefore, that may or may not put off buying that product because Apple is not able to allow the functionality in the context of blood oxygen. You know, explain your thinking on that to me about access to the technology and where current proceedings inhibit that for the consumer.
Thank you for asking me that question. I'm glad one of your audience did ask that, because this is actually really important to me. I have dedicated my life to helping improve people's healthcare. And I've done it through our innovation. I've done it through advocacy, philanthropy. So when someone says, hey, you took this away from me, I can't buy it anymore. Certainly the people who already have it, they can keep it. It really bothers me because unfortunately, this is one of those alternative universes that Apple has created. In their own internal documents, Apple knew their product wasn't good enough to be relied on medically. They knew it wasn't good enough for them to seek FDA clearance. But literally, they said, and this was in 2020, in the chaos of COVID, this is quotation in their document, if we launch pulse oximetry with our watch, we'll gain market share from Fitbit. That's why they launched it. Their own testing showed it measured twice a day at best on 37% of the population. Pulse oximetry is not useful unless it's a continuous monitor. Bad things happen during sleep. During sleep, you can have a desaturation that might be to apnea. You could have a dangerous desaturation that might be to opioid pain relief you may have taken. That's where the value comes. Our product, which is FDA cleared, can actually do 70,000 plus data points a day. It's a continuous, accurate pulse oximeter. So unfortunately, Apple is masquerading what they're offering to consumers as a reliable medical pulse oximeter, even though it is not. And I really can wholeheartedly tell you the consumers are better off without it. If they really need pulse oximetry on their wrist, they should buy ours, or they should find another solution that really is accurate and reliable, not something that gives you 2 measurements a day at best.